guest, Justice Ananga Patnaik, former Judge, Supreme Court of India, to address the congregation.
Good morning to all of you. Well, you just heard Mr. Ashok Parja, the Accreditation University. I go back to my professional days when I was the Senior Standing Counsel of the Sales Tax Department of Government of Odisha. And I saw so much of potential and talent in Mr. Ashok Parja that I ensured his appointment as the Additional Standing Counsel at Patnaik. And I'm very happy to say that today Mr. Ashok Parja is the Advocate of the State, leader of the bar, and I'm also very happy to say that my selection of Mr. Ashok Parja has been good. You've also heard Professor Ben Kumari, the Vice Chancellor of National Law, University of Odisha. I had not known Professor Ben Kumari, but I had heard from my son Aruna Patnaik that she is a very good teacher. And I also know when I was in Guwahati High Court as a judge, Professor Ben Kumari, Mr. Muralidharan was then an advocate, and Aruna Patnaik was then a student, my son, who to speak to you, had come to Guwahati to file an application for pardon of some Chauhan, young person who had been given punishment by the Supreme Court before the governor. But as years passed by, I saw Professor Ben Kumari twice. Once, I think maybe she was the director of the Vision Academy. Right in front of the Supreme Court, there was a function. She called me. And second time, when she was the dean of the law faculty in Delhi University, I was impressed. And I thought this lady deserves something better also. And I was the person, the chair committee, who was the chair of the search committee, who said she should be the vice chancellor of Patnaik. I'll come to Professor Vishwajit Patnaik. Vishwajit Patnaik came to me to file a case against Westcliff University when he was a student. He was denied admission to the MPhil course in Westcliff University, who he had merit. I filed a writ petition in High Court. And the matter came before a very brilliant judge, Justice R.C. Patnaik. And you look at the comparison of the students, oh, he's better, Mr. Patnaik is better. You give him admission, and that is how we secured his admission to MPhil. And I'm happy that I had also spotted and helped him out to get the admission, but it ultimately turned out to be a management person. And now he's founded this institution and heading it. Mr. Vinay Kumar Das, I don't know him, but I'm told I'm sure he proved to be a good dean. Ladies and gentlemen, and all the law and management students present here. I hope after having heard these lectures, the management students don't switch over to law. It's quite possible this has happened because I was a person who was initially going into medical, then came to arts and good law and changed it over. You make it persuasive and it's welcome. To switch out before you start your career, it's always welcome. Keep your mind open. I'm happy that you are attending it. Maybe you will say, no, this is a better option. Now, first of all, I'm coming to the topic. The topic, role of judiciary in a changing world. Yes, I did suggest role of judiciary as the topic for the seminar. But later on, I thought in the changing world it would be more appropriate because I received an invitation from Chief Justice Mr. Chandrachud to attend a lecture by the Chief Justice of the Singapore High Court, Justice Menon, on this topic, role of judiciary in a changing world. But let me tell you, that lecture was a long lecture, brilliant lecture. But I thought he spoke more about Singapore than about India. India conditions are different. And he had no idea what Indian judiciary is, what the conditions is in India. So all that he spoke was development. Yes, development is one aspect. Mr. Ashok was mentioned, I come to it. But we have to take into account our social conditions, our economic conditions, our political conditions, and then find out what should be the role of judiciary in changing world, that is India. In India. I'm not talking about US, I'm not talking about Singapore. You heard Professor Patnaik saying that social changes do influence law, and law also influences social changes. He quoted that. All this is fine. But this is on an academic level. We have read about Bentham, we have read about John Stuart. Sometimes we do quote the Supreme Court. I have quoted last week, I have quoted John Stuart Mill in my judgments. But more important is how those ideas apply to Indian conditions. That's very important. You heard a brilliant lecture by Professor Ved Kumari on family structures. It's kind of family structure. I think that's a very, very important aspect. Gender justice. She talked about how the Air India air hostesses were being retired prematurely from service. But now the Supreme Court interfered and said no premature retirement for ladies. But this, of course, does not apply to the private airlines. And after Air India going private, I don't know whether judgment will actually apply to Air India, because this discrimination, all that can only apply against the state. Article 14 says the state shall not deny equality of opportunity, equal protection of laws. Nobody can apply Article 14 in a family. That has to be by balance. What that she says is very fine, good. But you can't apply it by law. And regarding personal laws, yes, but the Supreme Court has, she rightly said, rapidly making influence. And the best example is the Triple Talaq case. In that Triple Talaq case, 3 out of 5 said no. Oh, Triple Talaq is arbitrary, manifestly arbitrary, and said illegal. Only thereafter Parliament. So Supreme Court is also intervening. But this judgment of Triple Talaq and there is certain judgments in privacy shows that Supreme Court takes into consideration changing situations and then decides the matter. As Mr. Ashok Bhatia says, what kind of cases are coming to Supreme Court? Supreme Court cannot sit down and lay down the law like that. It decides in a particular case. And that particular case is an opportunity to break the law. But while laying down the law, if like some of the judges have asked, would I don't know them, would meet them, if they import American thoughts into it and apply to Indian Hindu society, it becomes very difficult. That is what the present government is also worried about. You can't apply American thoughts, American jurisprudence, that all the rights that are developing to a Hindu family, to a husband-wife relationship. Very, very important matter that is there to go to Supreme Court. Getting marital rape. It was a divided opinion by the Delhi High Court. One judge said, no, marital rape is discriminatory. Therefore, if a husband rapes the wife without her consent, he should be brought up. I'll say, sorry, I don't agree with this. Because it will create a lot of problems in India. When there is a lot of dispute with the husband and the wife may go and give a complaint against the husband. FIR, next day, the family will get up. A good family and pregnant. Or some difference, because wives are carried by emotions. Men are also carried by emotions. Emotions will lead to something immediately which will be structure, affect this family structure. So one has to be very careful. Now, I will not touch those topics which they have said. I will touch topics mainly which have been left over. And my understanding the role of judiciary in the changing world is on the basis of whatever events are taking place presently in the country for the last 7 years. Because I think that is what needs to be addressed immediately. The first and foremost role of the judiciary in any country is to protect the life and liberty of a person against everybody, not only the state, everybody. Because life and personal liberty can be threatened by anybody, can be threatened by the state. And can also threatened by a private person. Even a father can also, father can protect, can threaten that human child. Husband can threaten it, wife can threaten it. So therefore, this right which is conferred under Article 21 of the Constitution, a person cannot be deprived by his personal liberty or life without the justice established by law. It was very narrowly construed earlier, Gopalan's case in 1950s. Was just established means state-made law. But now the Supreme Court says due process of law. Now the Supreme Court has expanded. Article 21 is the most important right of a person. But what happens is, when the state becomes very powerful, and the governments become very powerful, the executive, judiciary, instead of protecting the right, surrenders. This is the most unfortunate part of it. This is the most unfortunate. This is just the time when judiciary must stand and protect the right of personal liberty and life, judiciary. Because a very powerful political majority that the ruling dispensation has. This is exactly what happened in emergency. Like in 75-77, when Mr. Gandhi was in power, emergency was imposed. And when somebody went to court saying my personal liberty and my life being affected in the Madhya Pradesh High Court, a two-judge bench, Madhya Pradesh High Court, Justice A.P. Sen, his Tankha, said, no, in the emergency you might have suspended the right to move the court also. To enforce a fundamental right under Article 21. Right? But Article 21, personal liberty and life is not conferred by the Constitution. It is inherent in every human being. The Constitution has fully recognized. The matter went to Supreme Court. 4 out of 5 judges held. No, it is conferred by the Constitution. And said, in that case, Shukla was the ADM level. Unfortunately said, Supreme Court, in emergency power, everyone said, no, sorry, this also can be taken as a suspended. This you cannot move the courts when your personal liberty is affected or like that. Only one dissenting judge, Justice H.R. Khanna, stood out and said, sorry, this is an inherent right of a person. The Constitution will recognize it. No one can take it away. The state cannot take it away. The result was, Justice Khanna was superseded, no not able to change. Why not to change? Because executive, when it wants to be powerful, it does not bother about any limitations of that power. They will continue to be dictated. And it is the job of the judiciary, sorry, you can't do it. And that's exactly where the judiciary fails. This is the most unfortunate part. First role of a lawyer, of a court, is to protect the personal liberty. And that is why you see the powers of bail. Who has the bail? Does the executive have power to grant bail? Except the police, when the available offences they give. You have to go to court. Why? Whether it's the trial court, whether the sessions court, whether the high court, whether the Supreme Court, powers of bail are there. Why? So the responsibility of courts to ensure that the personal liberty of a person is not taken away without materials and without people. This is forgotten. Unfortunately, most courts have forgotten this. And I would say, not only most courts, except the highest court, they are sensitive. But they are not that sensitive. And that is why when habeas corpus petitions are filed, habeas corpus petitions produce the body of the person when somebody is confined. The court takes priority in it and said all other cases will remain as it is. That case will happen. Our habeas corpus petition will be given priority by courts, not given by the Supreme Court. We have to protect it. It's the most unfortunate one. And this is the first role. Second role of judiciary. I am saying all this because these roles are now forgotten. Today judiciary is thought something else. Civil disputes, like criminal cases, appeals. I come to criminal cases. But all this fundamental role of the court, which was established in common law back in the olden days in English courts, why the power went to the courts? Was it the power everything was given by His Majesty or Her Majesty? Dada ka darbar mein sab jata. Why it went away? I have delivered a judgment in what I could constitute in the 3-judge bench of the UADE, directly separating the judiciary from executive in Meghalaya. That judgment is pending, but it has been separated in the Supreme Court. First time, separate the subordinate judiciary, separate the criminal subordinate criminal judiciary, separate and put it under the High Court. Because it was under the government. And there is an act which was state policy. It says judiciary should be separated as far as possible. Earlier, you know, power was with the collector, who was also known as district magistrate. Why district magistrate? And judicial powers. Now, those powers have been taken away and given to the magistrates. The separation of powers. If executive power and judicial power remain the same hand, then there is bound to affect the liberty and control. That's the basic understanding of role of courts. So courts have been separated from Her Majesty or His Majesty only to ensure that personal liberty and rights are safe. And personal liberty and rights. The second role I am coming, protection and enforcement of all fundamental rights, as Professor Ved Kumar said. Part 3 of the Indian Constitution. And the state is prohibited to encroach into private property. They cannot. The moment it infringes, court will come. Then by and large, therefore, the courts are protecting fundamental rights. Presently also. But the courts are not protecting the fundamental rights of the minorities under Article 25, 26, 29 and 30. They are also part of it. Just because of majority rules, wherever it is, majority cannot control those rights. You read the papers, you see minorities suffering. Except in those states where there are minority community governments like Meghalaya. I have myself ruled that Christians are in majority, Hindus are in minority in Meghalaya. There is what they could have moved. There they cannot do it. In Kerala, they can't do it. Right? But in states where the notice bills are not mentioned as states, where the Hindu majority is ruling, in our country we have Christians also. In our country we have also Muslims. In our country we have all kinds of people. It's a variety. Should the courts not protect them? Why should the courts? That's the point I'm making. They're not failing their rules. That's the right. But they're failing. Why? Because either their own prejudices, judges' prejudices, or because they're scared of the majority. Very, very unfortunate situation. This is not what the Constitution is. This is the second rule. Third rule. This is what Dices had said, rule of law. No man is above the law, whatever his influence, rank, power, And in India it is equivalent form. Everybody is equal in law. And the courts does not make a discrimination between who is before him as an accused. If the court is scared of a very powerful person who is accused and immediately grants him bail, unfortunately, you must look into the merits. Just look into the merits. And start distinguishing between who is a weak person, who is not a strong person. I remember when I was judge in Patnaik and sitting in Shillong, another bench. A case came. A lunatic had been produced before the court as an accused. And there was a lady judge. You are so and so? Suddenly he said, no. Because so and so was the accused. Accused was some marionette. This fellow or lunatic in Meghalaya picked up from some place. He was going to lunatic asylum. From the lunatic asylum he had been sent for hospitalization. And the accused has also had been sent for hospitalization. Accused disappeared from the hospital and this lunatic was produced before the courts. Not once, number of times. And the lady had received only a noise saying no. What had happened is, lunatics have got some lucid intervals. When he was a lucid interval, the judge has asked this question, I'm so and so, I'm not so and so. Matter came to me. I ensured that it is released immediately. Paid compensation for the entire period. It was inside. And thank God, lady said, lady was the lady judge also. Right. And then the police started looking for that person. Actually, they could not get him. And this was a human rights case. This is Santosh Tripathi sitting there. It was a human rights case. It was reported. It is reported. Thank God that lawyer was able to, and it was published. The court has to say, right person is being brought. Right person is sent. This is very important. So this is a very important. Thank God, some powerful Babas have gone inside. Swamis have gone inside. One Misra, who was the son of a minister, who drove over a number of persons and killed. He was inside, just been released on bail. Thank God, this is called rule of law. If rich people or powerful people or influential people start influencing the courts, what will happen? It's a very important role. And we have to ensure that role continues. And media is also doing a good job here. They are reporting all the things. Next role. In the current changing world, it's very difficult to trust the investigations. Very difficult to trust the investigations. And investigations will not be fair. And these days when political interference is taking place, the investigation agencies, they are not right. So they might file a charge sheet. But it is the duty of the court to ensure that an innocent person does not go inside. They should be able to see through the investigations. Let me cite an instance which came before us in the Supreme Court. In Accreditation case, there was shooting incident. Terrorists shot, and then terrorists, all the terrorists got entered Accreditation case in Gujarat. They were all shot dead. Then the question came up, were there any persons who had conspired with them? FIR was lodged, let's find out the conspirators. For 1 year, nobody was known. Then the case was handed over to crime branch. Quota was applied. 11 Muslims were rounded up, and they were all convicted on the basis of confessions recorded by Mr. Manzara. You know the famous under the Quota Act, which is the only act under which police officer was given the power. No evidence, merely confession and linked with some corroboration. We find nothing wrong here except the confession recorded by was a serious offense. The law required, while sending this accused for confession, the magistrate must check whether they are free of any injuries. Right? Then, while returning from the confession, after the return, the magistrate should again check whether they are free. This is to rule out any torture, to ensure that the confession is voluntary. This is not been done. We acquitted them, all 11. 3 of them would have otherwise suffered death sentence confirmed by the High Court. And rest of them other punishments. So investigations. Earlier I had a good impression about the police, CBI. But with experience, in fact, I used to say, why Section 25 of the Evidence Act says confession for a police officer is not admissible. I used to question as a law. But gradually and gradually, I think, what a wonderful law based on English principle and Commonwealth law. If somebody gives a confession to a police officer, you can't take it as admissible. Section 27 makes some exceptions, but this is not. And therefore, when I was in the Supreme Court and I was just sitting in this decree, I ensured that a confession for a officer under the MBA Act should not also be admissible. Earlier, Justice Kabir said something else, I told the city, how can we admissible? He's equally bad. Equally bad and police officer. So we referred to Lajaban, got it bail, and Lajaban, they said, yes, he cannot be admissible. What is the changing scenario? Changing scenario is police officer and or investigating officer cannot be lied on. This is the basic principle set by that principle is reiterated time and again. Courts have to see whether there are other evidence or conviction. It's very important. Now see what is happening today. You see what is happening now. ED, CBI. You, from a reading of them, you find they are all political. Is this what is intended by the Constitution? And how can the judges, right from trial court to Supreme Court, not understand? The moment you see these
they're behaving politically. The court should apply everything and see whether the liberty has been taken away correctly. This is the point I made. And I'm making your youngsters, tomorrow you will be judges. Tomorrow you will be lawyers. You have to save this country from being taken over by rulers who can destroy our country and laws. Then, of course, the fast disposal of cases, criminal cases. And this fast disposal is very much possible. I was there in Chief Justice in Madhya Pradesh. We increased the number of judges, the trial courts. It can only be increased by number of judges, number of public prosecutors, and so on. And cases got disposed of. Artificial intelligence cannot replace adjudication. It has not been replaced adjudication. Right? Some man has to judge all over the world. So you have to man the courts with more number of judges, absolutely necessary. More number of judges, more number of judges, more number of judges. Right? So this is absolutely necessary. It's very much possible they get piled up in the High Court articles. Appeals. I remember when I left Madhya Pradesh, the Supreme Court Justice Chavan gave a judgment in which one paragraph said, how can it be in 9 months from date of filing of a charge sheet, the case has travelled from the trial court to the High Court, the Supreme Court, and court. That should be the speed of criminal cases. Very, very important. That how the court will expedite it, that's very, very important. I am told in courts, adjournments, in high courts, adjournments. That has to change. That is the role of court, expedite. Now I come to what Mr. Ashok mentioned about early resolution of civil and commercial disputes. This is a developing country. In a developing country, this disputes have to be done as fast as possible. That apart, there are some matters which have to be disposed of immediately. I remember when I was the Odisha High Court judge, the new 2003 Electricity Act came. And they had been given the power to discourage power. Every day, disconnection notice is there and they will come to the High Court. Right? And I give one notice, there the disconnection next day is put off. Otherwise, if they don't pay, the electricity distribution suffers. You get disconnected, and the poor consumer suffers. Fast disposal is not. Commercial disputes. Now, Mr. Parija mentioned commercial. What commercial disputes? Where courts cannot take up commercial disputes. Therefore, they provide an arbitration clause which go to arbitration. And most of the matters, big commercial disputes are coming to arbitration. Because courts, you cannot send out criminal cases, constitutional cases, matrimonial cases to arbitration. It's not possible. For that, courts are there. So commercial dispute, we send it out. Other civil disputes, send it out to arbitration. And arbitration should be very fast. Mr. Parija mentioned that the number of arbitrations I can. Yes, I can assure you a lot of prospects in arbitration. The amount of money I have earned after retirement through arbitration, I would have earned even if I was 50 years as a judge. So much money I have earned arbitration after retirement from 2014 to 2020. Why? because I started doing arbitrations. And how I got arbitrations, I don't know. I never got it from parties. I am not known. I am not known outside. I got arbitrations for two reasons. First reason is I was very fast. I was very fast. So other persons who are arbitrated dominate with preside. Similarly, courts, like Justice Bundina, like Justice Bundina, but he gave me to decide the dispute to arbitration. The other penalties. And telephone to me, I have given this, you must decide it. Why have you given it to me? He said, I want fast. Speed. Speed is very important. But unfortunately, after the award is made, he gets stuck with the commercial or the decisions. They have no knowledge. There is no thinking on it also. They give it to the commercial courts or district courts. They have no idea of building. They have no idea of grasp. So it is better to train some persons and appoint people in commercial courts who are well versed in it. And Mr. Parija also mentioned about technology. Today, all my arbitrations are through video conference. Earlier, I used to travel to Singapore, to Paris, to London, to Bombay, to Bangalore, to Raipur, to Hyderabad, everywhere to arbitrate. Now I don't have to travel anywhere unless the parties want to. I do it in my own office, in front of a television screen, all arguments proceed, and a 3-member tribunals. These are all changes one has to adopt. And I'm happy that in Odisha, fast changing, it may have some displacement. Lawyers in Odisha High Court, they start making these cases. Like a development when it takes place, Narmada Bachao, dam is in somebody has been hosted. They have to rehabilitate it. Right? So it has a displacing effect. So this also has a displacing effect. Very lawyers will go about it. But the best way is nobody can stop the changes of technology. Nobody can stop it. You see how politicians are adopting. After Mr. Modi adopted Twitter, what we call all kinds of technology. Mr. Patnaik also adopted. All chief ministers are adopting political leaders. Without that, we are gone. They are after competition in politics. Similarly, unless the courts also adapt to this technology, like examining witnesses, witnesses don't have to come. When Madhya Pradesh I was Chief Justice, we have constructed house in every district courts. Why? For witness to come and stay. Right? And witnesses will eat there, stay there, attend the court. Next day the case will go, witness will stay there. This is not necessary. A video conference, witness will examine. A witness from Australia can also be examined here. Witness from London can be examined here. Every through technology. This is now changing. The courts must adapt it. Finally, climate change and environment. Pollution. Professor Vidmari rightly said, pollution means entire pollution. Not only Supreme Court, not only High Court. Supreme Court, I was there in the mid bench. Government, 3-year bench. Supreme Court starts it. But High Court should look at that. That's also looked at that. entity is also there. But do you know, as far as the 1970s, in Ratlam municipality case, a trial court, as Krishna said, trial court has the power. Nuisance is there in CRPC. You have the power to do nuisance. You go to any street anywhere, so much of nuisance is there. Somewhere it is garbage, somewhere it is something. So this environment has to be cleared up by courts also. Many powers there. These are only some of them. So these, in the changing situation, these are some of the roles of the courts or judiciary, which I want to mention. Thank you.
Patnaik, founder and president of ASBM University, to felicitate the guest. I request Justice Ananda Patnaik to kindly accept a memento as a token of our gratitude. Kindly accept a memento as a token of our gratitude.